Breaking news out of the Centennial State. The Supreme Court of Colorado has ruled that former President Donald J. Trump is ineligible to be on the ballot in Colorado. What does this mean for the election of 2024 and for the chances of the presumptive frontrunner for the GOP nomination? Hang on, folks. We're going to get into all this in just 1 second.
My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk.
Number one for the state of Colorado. Nothing. By the judge alone. Late Tuesday evening, news came out of Colorado that has absolutely woken up the nation at a time that we normally rest at Christmas from all the political discussions that go on in our country. The Supreme Court of Colorado has ruled that former President Donald J. Trump will not be allowed on the Colorado ballot. I take you straight to an article by the Associated Press. Headline: Donald Trump banned from Colorado ballot in historic ruling by state Supreme Court. Article written by Nicholas Riccardi. We read the following. A divided Colorado Supreme Court on Tuesday declared former President Donald Trump ineligible for the White House under the U.S. Constitution's insurrection clause and removed him from the state's presidential primary ballot, setting up a likely showdown in the nation's highest court to decide whether the frontrunner for the GOP nomination can remain in the race. The decision from a court whose justices were all appointed by Democratic governors marks the first time in history that Section 3 of the 14th Amendment has been used to disqualify a presidential candidate. Quote, a majority of the court holds that Trump is disqualified from holding the office of president under Section 3 of the 14th Amendment, the court wrote in its 4-3 decision. Colorado's highest court overturned a ruling from a district court judge who found that Trump incited an insurrection for his role in the January 6, 2021 attack on the Capitol, but said he could not be barred from the ballot because it was unclear that the provision was intended to cover the presidency. Reading further into the article, the court stayed its decision until January 4 or until the Supreme Court rules on the case. Colorado officials say the issue must be settled by January 5th, the deadline for the state to print its presidential primary ballots. Quote, we do not reach these conclusions lightly, wrote the court's majority. We are mindful of the magnitude and weight of the questions now before us. We are likewise mindful of the solemn duty to apply the law without fear or favor and without being swayed by public reaction to the decisions that the law mandates we reach. Trump's attorneys had promised to appeal any disqualification immediately to the nation's highest court, which has the final say about constitutional matters. Trump's legal spokesman, Alina Habba, said in a statement Tuesday night, this ruling issued by the Colorado Supreme Court attacks the very heart of the nation's democracy. It will not stand, and we trust that the Supreme Court will reverse this unconstitutional order. Okay, let's get into this. Sorry for the lengthy read, but I think we need to get the whole context of what's going on here. If you'll remember, very early on this month, a district judge in Colorado ruled a technicality. She said that Trump had engaged in insurrection. However, the language of Section 3 of the 14th Amendment was so vague that she could not plainly determine whether or not the office of President of the United States was intended to be listed among those that Section 3 applied to. Well, the decision was appealed from both sides. The 6 Republican voters and independent voters appealed up to the Colorado Supreme Court along with Trump, although Trump and his lawyers did it for different reasons. They wanted the Colorado court to determine that Trump had not engaged in insurrection. Therefore, the whole question of Section 3 of the 14th Amendment would never even apply to him. If there's no charge of insurrection, You can't use the provision of the 14th Amendment. Well, Trump got what he wanted, an appeal up to the state Supreme Court. What he didn't expect was the ruling that got handed down to him. So let's take a look at part of that ruling, and then we're going to make some comments. I take you to the ruling. It's about 213 pages. Don't worry, we're not going to read all of it. I am going to read a couple of parts of it. In this appeal from a district court proceeding under the Colorado Election Code, the Supreme Court considers whether President Donald J. Trump may appear on the Colorado Republican presidential primary ballot in 2024. A majority of this court holds that President Trump is disqualified from holding the office of president under Section 3 of the 14th Amendment to the United States Constitution. Because he is disqualified, it would be a wrongful act under the election code for the Colorado Secretary of State to list him as a candidate on the presidential primary ballot. The court stays its ruling until January 4, 2024, subject to any further appellate proceedings. Reading a little bit further into the ruling, more than 3 months ago, a group of Colorado electors eligible to vote in the Republican presidential primary, both registered Republicans and unaffiliated voters, the electors, filed a lengthy petition in the district court for the city and county of Denver, asking the court to rule that former President Donald J. Trump may not appear on the Colorado presidential primary ballot. Invoking provisions of Colorado's Uniform Election Code of 1992, the electors requested that the district court prohibit Jenna Griswold, in her official capacity as Colorado's Secretary of State, from placing President Trump's name on the presidential primary ballot. They claimed that Section 3 of the 14th Amendment to the U.S. Constitution disqualified President Trump from seeking the presidency. More specifically, they asserted that he was ineligible under Section 3 because he engaged in insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. Going a little bit further into this ruling, after permitting President Trump and the Colorado Republican State Central Committee to intervene in the action below, the district court conducted a 5-day trial. The court found by clear and convincing evidence that President Trump engaged in insurrection, as those terms are used in Section 3, Anderson v. Griswold. But the district court concluded Section 3 does not apply to the president. Therefore, the court denied the petition to keep President Trump off the presidential primary ballot. Part 6 conclusion. Electors and President Trump sought this court's review of various rulings by the district court. We affirm in part and reverse in part. We hold as follows. The election code allows electors to challenge President Trump's status as a qualified candidate based on Section 3. Indeed, the election code provides the electors their only viable means of litigating whether President Trump is disqualified from holding office under Section 3. Congress does not need to pass implementing legislation for Section 3's disqualification provisions to attach, and Section 3 is, in that sense, self-executing. Judicial review of President Trump's eligibility for office under Section 3 is not precluded by the political question doctrine. Section 3 encompasses the office of the presidency and someone who has taken an oath as president. On this point, the district court committed reversible error. The district court did not abuse its discretion in admitting provisions of Congress's January 6th report into evidence at trial. The district court did not err in concluding that the events of the U.S. Capitol on January 6th constituted an insurrection. The court did not err in concluding that President Trump engaged in insurrection through his personal actions. President Trump's speech inciting the crowd that breached the U.S. Capitol on January 6, 2021 was not protected by the First Amendment. The sum of these parts is this. President Trump is disqualified from holding the office of president under Section 3. Because he is disqualified, it would be a wrongful act under the election code for the secretary to list him as a candidate on the presidential primary ballot. We do not reach these conclusions lightly. We are mindful of the magnitude and weight of the questions now before us. We are likewise mindful of our solemn duty to apply the law without fear or favor and without being swayed by public reaction to the decisions that the law mandates we reach. We are also cognizant that we travel in uncharted territory, no kidding, and that this case presents several issues of first impression. But our resolution of the elector's challenge under the election code, the secretary would be required to include President Trump's name on the 24 presidential ballot. Therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling until January 4, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. If review is sought in the U.S. Supreme Court before the stay expires on January 4, 2024, then the stay shall remain in place and the Secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. Okay, now let's really get into this. 213 pages of a ruling, a divided state Supreme Court, 4-3, a conclusion that half of the country is absolutely furious about, and the other half is cheering as if everybody has all hit the lottery at the same time. So, what do I think about all this? Okay, having had a little bit of time to cool off and read these sections over and over again and listen to some sage counsel from people who I respect, I come to the following conclusions. Number one, this is a 213-page ruling of yada, yada, yada. What am I talking about? Very simple. They've ruled that Trump did engage in an insurrection, much like Judge Wallace did at the district court level. Unlike Judge Wallace, they ruled that under Section 3 of the 14th Amendment, Trump is excluded from being on the Colorado ballot for the 2024 primary election and vis-a-vis the general election. And if the court enforced their order, then I'd be even more upset than what I already am right now. However, there is something that I need to point out to everyone, and I will read this again, albeit very quickly. Therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling until January 4, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. If review is sought by the U.S. Supreme Court before the stay expires on January 4, 2024, then the stay shall remain in place and the Secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. I said a moment ago that this is a 213-page ruling of yada, yada, yada. Basically, what I mean is this. If the Colorado Supreme Court let the effect of their ruling take place, then Secretary of State Griswold of Colorado could go ahead and exclude Trump from the ballot, but the court gave itself an out. They said, look, we realize we're in uncharted water here. Therefore, we're going to put a stay on the effect of our ruling until January 4. And if this decision is appealed up to the Supreme Court, not even that the court rules on it yet, but if it's even just appealed before the deadline when the stay would come off, then the stay would continue on until the Supreme Court finally does rule on this, which means the practical effect of this ruling is nothing. Trump remains on the ballot in Colorado. So you begin to understand why I'm a little bit upset about this. With all due respect to the Colorado Supreme Court, quit trying to have your cake and eat it too. If a majority of you really think Trump ought not be on the ballot, fine. Let your ruling go into effect, but you didn't do it. Now, I also understand this is a very volatile question, and the times in which we find ourselves are very, very touchy. As I said, half the country right now is pissed as hell over this. So I can sort of understand in one sense why the Colorado State Supreme Court didn't let the effect of the ruling take place. In other words, Trump is excluded from the ballot. So it's a 213-page ruling of yada, yada, yada. A lot of Seinfeld. As you might imagine, the Trump campaign immediately responded to this, and I'll show you exactly what they said. Here is a statement from their campaign. Unsurprisingly, all Democrat appointed Colorado Supreme Court has ruled against President Trump, supporting a Soros funded left wing group scheme to interfere in an election on behalf of crooked Joe Biden by removing President Trump's name from the ballot. That's not the practical effect for right now. And eliminating the rights of Colorado voters to vote for the candidate of their choice. Democrat Party leaders are in a state of paranoia over the growing dominant lead President Trump has amassed in the polls. They have lost faith in the failed Biden presidency and are now doing everything they can to stop the American voters from throwing them out of office next November. The Colorado Supreme Court issued a completely flawed decision tonight, and we will swiftly file an appeal to the United States Supreme Court and a concurrent request for a stay of the deeply undemocratic decision. We have full confidence that the U.S. Supreme Court will quickly rule in our favor and finally put an end to these unlawful, un American lawsuits. Stephen Chung, Trump campaign spokesman. Okay. Now, no offense to the Trump campaign. You're hyping this even worse than the Colorado State Supreme Court. The statement that says, by removing President Trump's name from the ballot, his name is not removed from the ballot. The practical effect of this 213-page ruling, Trump's name is on the ballot by virtue of a stay of the Colorado Supreme Court. His name remains on the ballot till January the 4th. And if the ruling is appealed to the U.S. Supreme Court, which the Trump campaign has every intention of doing, it will continue to remain on the ballot until the U.S. Supreme Court rules on this matter. And that's not necessarily my opinion, by the way. Here's an update from CNN from earlier, and I think this is definitely worth taking a look at. So let me pull this up for your benefit. One moment. This is definitely worth a read. Take a look at this. From CNN staff, appeals process could keep Trump on the primary ballot in Colorado, analyst says. Donald Trump could remain on Colorado's presidential primary ballot if the former president decides to appeal the state Supreme Court's decision that ordered his removal Tuesday. If Trump even asks the U.S. Supreme Court to step in by January 4th, the date set by the Colorado State Supreme Court for parties to appeal the decision will remain paused, according to Stephen Valdek, CNN Supreme Court analyst and professor at the University of Texas Law School. That means the GOP frontrunner will, quote, almost certainly remain on the Colorado primary ballot on March 5th, according to Valdek. So, yada, yada, yada. Tens of millions of people across this country right now have their blood pressure up, their faces have gone red, their teeth have been clenched over a ruling that is the equivalent of a Seinfeld. I know I'm being a little bit snarky and very sarcastic with that statement, but that's basically what it is. It's a whole lot of ruling about nothing. The Colorado Supreme Court gets to give their opinion why, yes, by God, Donald J. Trump committed insurrection, and yes, by God, Section 3 of the 14th Amendment applies to him. He shouldn't be on the ballot, but we know we are in uncharted territory. Therefore, we, the high and noble court who knows better than all you plebeians out there, we determine that Trump shall be allowed to remain on the ballot. We stay on the effect of our ruling. Oh, well, thank you, all high and mighty Supreme Court. Okay, let's talk about the political ramifications of all this. Legally, Trump's going to remain on the ballot in Colorado. And even if this goes to the U.S. Supreme Court, I'll be shocked if they uphold the Colorado ruling, because if they do, that means state Supreme Courts around this country are going to go like this, and they're going to start taking Trump off the ballot. And there is no way that tens of millions of people across this country are going to tolerate that. And while the Supreme Court of the United States is supposed to be, shall we say, ignorant of public sentiment, that's not true. They know just as much about what's going on in the court of public opinion as people who are involved in the political process itself. They realize full well, much like the Colorado Supreme Court, what would happen if they uphold Colorado's decision. So in Colorado, Trump's going to remain on the ballot. What does this mean for other lawsuits around the country? This gives them fresh ammunition to keep filing them until such time as the Supreme Court rules on this. What does this mean for Trump as a candidate? Well, it depends on which election you're talking about. There's been a whole spate of polls that have come out this week that show that Trump continues to have a stranglehold on the GOP nomination. I have a funny feeling that when the next round of polls come out and they have the opportunity to take into account this news out of Colorado, that his numbers will go even higher than where they are right now. That's the GOP nomination race. The general election, same thing, although probably not quite as pronounced. The lead that he enjoys against Joe Biden will continue to increase. Why? Because the practical political effect of this decision is that it's going to reinforce what voters already think about this situation. Hey, they're trying to keep this guy off the ballot. I may not like him. I may not always agree with him, but daggone it, you ought to have the right to run for office. Even fair-minded Americans, even if they weren't Trump voters, are going to come to that conclusion, and it's just going to drive more people to Trump. Maybe not in large amounts, especially in the general election context, but it will continue to drive them. You'll see more support from African Americans. You'll see more support from Hispanics, especially if they've come out of Central and South America. You'll see more support among young people because they're looking at Trump and they're realizing this may be the last shot we've got at getting some measure of prosperity back in our country, and they're trying to keep him out of office. Like I said, half the country right now is real happy about this decision. I don't know that I'd be so happy about this if I were them. Because if this does, as everything else has done up to this point where Trump's renewed candidacy for president is concerned, this is probably going to redound to their detriment. So, Merry Christmas, America, from the Centennial State. But that's what I think about it. What do you think? As we start to wrap up this video, please do me some favors as always. Number one, if you're not a subscriber to my channel, please do so. Number two, please leave a comment below. I would love to know what you think about all this. Number three, please share the video around. Let's get this out there to everybody and get their take on it. Number four, don't forget to hit the bell for notifications. I want to make sure you're always aware when new material is coming out, be it a video or a live stream. And finally, please give me a thumbs up. My name is Brian Trippett. I am your front porch conservative, and I will see you next time.